I'm absolutely delighted to be holding today's roundtable discussion on the state of aviation today. It's a globally interconnected sector. Of course, it is much more than just about passengers and cargo going from A to B and to C. It is the whole supply chain, the ownership structure around it, both on the commercial and, of course, the private, the business side. And so it's a sector that has undergone clearly a huge amount of disruption with the restrictions of the pandemic. And just when things were starting to open up again, clearly geopolitical change, the war in the Ukraine, the sanctions and their repercussions has created yet another ripple effect across the world and across the aviation sector. Today, I'm thrilled to have Safak Herdem, who is managing partner of Herdem Attorneys, our member firm in Istanbul, Samuel Morales of Aracarena, our firm in Venezuela, Bajal Shah of 24 Old Buildings Chambers, a barrister there who works very closely with Mackrell Solicitors, our London-based member firm. And I'm hoping that Aoife Sullivan from the Air Law Firm and British Business General Aviation Association, there's a mouthful, will join us shortly. But we have a huge amount to get through. I've asked Safak to chair and drive today's session, but suffice to say, we have aviation experts on the panel who are going to share their perspectives and wisdom with you. So I'm going to hand over to you, Safak, to start us off.
Thank you very much, Kate. Thank you for all to joining us today. I actually want to make a very short disclaimer that as the matter is very critical, we discussed with the colleagues before we start that anything we will be presenting on will not be a legal opinion. So we will be just giving a general perspective on the sanctions and the aviation related issues. So I would like to start with the Russian aviation markets, and me as a personal also having a special focus on the aerospace and the aerospace related technologies. Of course, this is a big major impact in this area, and we see that there are both in sanctions and some export control restrictions now imposed to Russia and Belarus. So let me give some figures before we start. That I had a quick search on the Russian market, and I think it is the fourth largest international market in the aviation. And at the start of the conflict, there were more than 950 commercial aircraft with the airlines in Russia when the sanctions began. And for the leasing market, Russia holds around 500% of the overall global operating lease portfolio. That's by value, but around 4% of the international operating lease market. And I look out also the number of the commercial aircrafts recorded on lease with the Russian airlines from non-Russian lessors in the first month of the conflict. It was around 515, and 39 aircraft were out of Russia when the conflict started, and 157 remain in Russia, and more than 25 re-registered from Bermuda to Russia, and further more than 5 from Ireland to the Russia. So it's a big market, it's a huge market. Of course, it has been hit by the sanctions, and we don't know also about the number of the aircraft, which is more than 400, which potentially lost after these sanctions imposed to Russia. Maybe they have been owned by the Russians in the backstage, but registered in the European countries. So what are the sanctions, and what in general, what might be the implication of sanctions in the aviation industry? I think it's about the jurisdiction, and always people are asking the same question: why the U.S. or the EU sanctions are binding me in this regard. So actually, from the export control matter, the basic answer is about if it is related to any U.S. source content, then the U.S. law will be applicable. And we know that the U.S. sanction regime is classified in two sanctions, both in the primary, first in the primary and the secondary sanctions. And outside of the United States, all economic sanctions imposed by a country are in general the primary sanctions, but the secondary sanctions are also impose the penalties on the persons and the organizations, entities not subject to the sanctioning country's legal jurisdiction, and they are all applied against the entities engaged in the same dealings which are prohibited. And if a party violating the prohibitions or the restrictions subject to secondary sanctions is also the one subject to the regulatory and they will be subject to regulatory consequences of these issues. So that is for some it's a global sanctions regime. For some it is just a multilateral sanctions regime, but in any case it is applied, and I don't think that we have not seen yet, but actually I don't think soon we will be seeing any secondary sanctions imposed by the US. But if the violations continues, as the BIS of the United States announced recently, maybe in the midterm there might be some possible secondary sanctions as applied in the Iranian sanctions by the US. And I just want to give us some little information about the Commerce Department of the United States, and they have also taken some measures and imposed some restrictions on 24th of February, and the further extended it on March 13. And they also announced a policy of the denial for all aircrafts and the associated parts and the items, also the services. What's important with the BIS is targeting the people, any people in any jurisdiction. So it doesn't matter if you are a US person or not, or fall under the secondary sanctions or not, or no. The only critical point in here is if you are using a US source content. So in the BIS perspective, they imposed highly restrictive license requirements on all categories of the items on the commerce control list to the Russia and also the Belarus, and they have expanded the almost many transactions and expanded it to the sensitive dual use technologies, software, and the commodities that could be used by the Russian government and the Russian people. There are some issues which we have highlighted during our work for the clients, that all legislations do not only cover the Russians and the use in the Russia, or for the benefit of use in the Russia, maybe also subject to a legal restriction. And recently BIS has also identified the apparent violations for over 100 aircrafts, and they clearly announced that any assistance to those aircrafts will be deemed as a violation of the export regulations of the United States. From the EU perspective, on 25th February, the EU first set of sanctions have been introduced, which is targeting the aviation industry. It's very straightforward, and it says that it shall be prohibited to sell, supply, transfer, or export directly or indirectly any good technology suited for the use in the aviation and the space industry in Russia, or for the use in Russia. And then further, it is prohibited to provide the insurance and the reinsurance in relation to goods and the technology which have been restricted. And these also include the ban on the brokering services and the financial assistance and any type of the facilitation. In that regard, even the non-Russian operators that operate a Russian registered aircraft are affected by these measures, and these ban also concerns to the private flights of the aircrafts owned or leased by the Russian citizens or the Russian companies. And further, this ban also concerns the EU or the third country registered aircraft which are leased by the Russian citizens. Of course, there are some wind down periods in the EU and the US legislations, in contrary to the UK approach. And I will leave the stage to Bejel to give in detail about the UK sanctions in the aviation. But as far as I read that it's parallel, but a bit detailed with the broader language of the EU and the US sanctions. And the UK doesn't announce any wind down period. So if there is any sanction announced, then it will be affected at the time of the announcements. And but I think there will be some wind up periods for some certain issues, as the industry dynamics are not ready yet for the compliance of the sanctions. And I mentioned about Bermuda, and Bermuda is also a good trade partner in the aviation of Russian aviation industry. On 12th March, Bermuda has also suspended the airworthiness certificates of the Russian aircrafts. And Bermuda is also following up the similar UK and the EU sanctions in the aviation industry. In the meanwhile, there have been some countermeasures by Russia, and Russia announced all Russian aircrafts to come back to Russia. And there is a little strange law in Russia now, as at a countermeasure which was enacted on 11 March, that is government that entitles the government to change the conditions of the leasing of the aircraft. So it will be an interruption of the government to a civil and a financial leasing transaction. I don't know what might be the impacts or if it's applied or not. And as we all know that Russia has listed unfriendly countries and taking some measures against them. And the Russia has also started to apply the dual registry in the airworthiness, and if any country rejects the airworthiness of an aircraft, then Russia will welcome it, and they will be able to register it. This is a very general spectrum of the sanctions, and Bejel will follow up with the UK sanctions regime, and of course for the lawyers and the legal counsels that will be a ripple impact, especially in the contracts, and we will see so many force majeure issues, and we will be facing with many aviation type disputes. I will leave the floor to Bejel to talk about this, and then if Eva will be able to join us, I hope she will be giving some perspective from the private and the business jets industry. And then for the best case scenario, we know that the Venezuela has suffered for a long time for the sanctions, and Samuel is a very good expert in how to deal and how to manage the compliance in the Iranian and the Venezuelan cases, especially in the aviation industry. Bejel?
Shafak, thank you very much, and hello, good morning, good afternoon, and good evening, everybody else, and thank you so much for joining us on this webinar on this really interesting topic. What I want to focus on are the following matters, which I hope will be of some assistance based on my experience dealing with aviation issues in England. I want to touch very briefly on some of the sanction regimes that are now currently applicable and which affect the aviation sector in particular. I then want to touch on force majeure clauses that one often finds in aircraft leases and aircraft purchase agreements, and just give a sort of an outline of the sort of points that one needs to watch out for. I also want to discuss very briefly some of the other English law techniques or doctrines that could be affected, that could come into play because of the various sanctions regimes. So dealing first with the sanctions regimes, so Shafak has given a very comprehensive view of the regimes that applied in the US and in the EU as well. Now, the UK inherited the EU sanctions measures, and essentially we have replicated those measures after we left the European Union. The main instrument by which we have done this as regards Russia is a regulation called the Russia Sanctions EU Exit Amendment Regulation 2022. And the way that that particular regime operates is that it provides, or it allows the relevant Secretary of State to designate various persons or various institutions as receiving sanctions. And then once that happens, a cascade of particular prohibitions and issues apply. So for example, once someone has been designated under those regimes, it then becomes unlawful for other people to supply them with services or finances or financial support if you believe or you have reason to suspect that you will be benefiting someone who is sanctioned or someone who is, for example, connected with the Russian government. Now, the way the sanctions program unfolded was that the UK had a series of rolling sanctions. So first, certain individuals, certain oligarchs were sanctioned, then various Russian companies and Russian banks, and then the net was widened out. The upshot of these quite complex provisions is as follows. As regards Russian banks, it is now unlawful for anyone to provide them with services in sterling and for SWIFT clearance in the UK, and also to provide payment or to the designated Russian banks. As regards many Russian companies that are again designated, it has become unlawful for them to raise financing in the UK. And as regards various designated persons, the oligarchs, for example, they cannot dispose of or deal with their assets. In theory, the measures apply to their worldwide assets, but in practice, it's arguable that only the UK situs assets are the ones caught by the UK sanctions regime. But the point has yet to be determined. And then the other measure that is obviously important in our field is the ban on Russian airlines flying into UK aerospace and landing at UK airports. And that obviously has curtailed any traffic between, any direct traffic flights between the UK and Russia as well. Now, that's a very sort of potted summary, if you like, of the main sanctions regimes that apply in the UK. The devil with all of this is actually in the detail, and any questions on sanctions, one always has to go back to the particular legislation. My experience is that this is a particularly difficult area because there have been so many amendments and changes to the legislation and to the regimes that have been coming in, and one always has to go back to see what the latest texts are that apply. Now, with that thumbnail sketch of the sanctions regime, I wanted to touch on some of the areas that these things impact on, and of course, one of the main impacts that the sanctions regimes have had is on aircraft leasing. And in particular, what we have seen happening is that many aircraft lessors have tried to recover their aircraft as quickly as they could when the aircraft were outside of Russia. And the other thing that this has triggered is termination by many aircraft lessors of the actual aircraft leases themselves. Now, one of the points that always arises in this type of situation is consideration of whether the aircraft lease permits those measures. Now, as with all questions under English law and English aircraft leases, you have to go to the actual wording of the particular clauses and to see whether they permit termination. Usually in a well-drafted lease, the lessor is given a power to terminate the lease if, for example, the performance of the lease becomes illegal. And one could, for example, imagine a situation that for the lessor, the provision of the aircraft, the provision of the metal may be regarded as illegal under a particular sanctions regime, and that may then trigger the ability to terminate for illegality. Sometimes there may be a different route to termination. If, for example, the results of the sanctions regimes or the situation is that the lessee is not going to be able to pay and pay in dollars, which tends to be the main currency for payment under aircraft leases. If the lessee is not going to be able to pay in dollars, then that may also trigger an ability to terminate the aircraft lease. Now, one of the questions that often gets asked in this type of situation is as force majeure, and whether force majeure clauses may apply. Now, just to go back to basics, what am I referring to here when I'm talking about a force majeure clause? And to give it its sort of widest definition, it's a clause in an agreement that essentially excuses one side from performance of an agreement because of circumstances beyond their control. That's, if you like, a broader description of how a force majeure clause is regarded. Again, everything depends on the particular wording of the force majeure clauses. Now, one interesting question that I think is coming through at the moment is whether force majeure clauses that refer to war may be applicable because of what is happening as regards Russia. In other words, Russia's invasion of Ukraine. Now, Russia hasn't actually declared war on Ukraine. As far as Russia is concerned, it is simply carrying out a special military operation. And so one would then have to look in a force majeure clause to see whether there is other language that could cater for this sort of scenario. For example, words such as conflict or invasion, and to see whether those situations are encompassed by the clause. And then one has to look at the actual clause to see what the clause is actually dealing with. Now, often force majeure clauses are very tightly drawn. They won't excuse performance if something has simply become more expensive or difficult to do. You really need to be able to argue that the actual performance has become impossible or illegal, so either physically impossible or legally unlawful to continue. That's the way the majority of them are drafted. Again, much depends on the actual wording itself. And then another point to watch out for in force majeure clauses is whether what you want to be relieved of are the consequences of performance or the actual performance itself. Again, that's a distinction that many force majeure clauses and the jurisprudence can draw. So often the actual performance may be excused, but if what you want to be relieved against are the consequences of performance, the force majeure clause may not actually help you there. The point to take away is always look very carefully at force majeure clauses and to see whether they cover this type of scenario. Another doctrine that sometimes is prayed in aid in this type of situation is illegality. illegality under English law, to give again a very broad description, is where either the making of the contract was illegal or the performance of a particular obligation is illegal, or the purpose of the contract was to effect an illegality. Now, I think with the sanctions regimes, the argument would probably focus on the second of those scenarios, namely that the performance of certain contracts has become illegal. Again, with illegality is actually a very fact-specific doctrine. One has to look at all the particular circumstances to see whether what it is that the contract covers, whether any particular clauses have become illegal, the performance of them have become illegal. If they have, then the consequence is that essentially the contract is no longer enforceable, and you bring the contractual obligations to an end. It is quite a fact-specific and a policy-specific doctrines. Then to touch on a few other additional points, one of the results of the sanctions regimes is that two of the largest aircraft lessors have found that their aircraft are now stuck in Russia. So Air Lease Corporation, I think, has about 21 aircraft that are stuck in Russia. One of the other huge lessors, AerCap, I think they have perhaps 100 aircraft stuck in Russia because of what has happened. They're currently unable to recover them. And so the natural route that many of the aircraft lessors are looking at is to see whether they can make a claim under their insurance cover, possibly their war risks cover, to see whether they may be able to pay out. Now, this is we're in the very early days of this, and it'll be very interesting to see how this develops. But again, much will depend on the actual policy wordings and the war risk clauses to see if they're actually triggered by what has happened, bearing in mind that Russia hasn't actually declared war, but what it has effectively done is nationalize or appropriate aircraft belonging to others. I think that's probably all I want to say. And of course, I'm happy to take any questions later on, but thank you very much for your attention.
Thank you, Majel. I think I will have a couple of questions actually about the force majeure issues after all speakers presented. I assume Aoife has joined us, and I will now leave her to give some insights for the private and the business jets, and also from the EU perspective. Aoife?
Thanks, Afak. How are you? Thanks for having me on. So my goal here today is just to give some perspective on the business and private aviation part of the aerospace sector, which has obviously been as heavily impacted as the airline sector, and to some degree more so. The issue we have been experiencing, and I have to, mention here that the DFT in the UK have been particularly helpful in terms of helping us to analyze the sanctions, the impact of the sanctions, but there is a significant amount of what I would call collateral damage to the sanctions. And I mean that in terms of the sanctions regime was intended to target designated persons under the legislation. What has actually happened is that non-sanctioned have also been heavily impacted. So we have had, over the course of the last couple of months, the kind of work that we've been involved in has included, for example, the manufacturers refusing to supply parts to aircraft. And we're seeing this more so in business and private aviation than in the commercial sector. And I suspect that there are many different reasons for that, but certainly in the private sector, the the OEMs basically refused to supply parts. In some cases, they issued notices based on the flight path of particular aircraft. So just because it had happened to fly to Moscow previously in the previous month, they used that as a method of determining that it was an aircraft that was for use in Russia. So we've had to challenge them on it. And one of the OEMs in particular issued what they called a self-certification. So basically wording that says, well, you, the operator of the aircraft, and bearing in mind in private aviation, the operator is separate from the owner. So it's not like the airline industry where the owner or the lessee is typically also the operator and the maintainer of the aircraft. In private aviation, there are a lot of independent third parties who are all supporting the operation and use of the aircraft. But in that they asked for the operator to provide certification that the aircraft is not Russian owned, it is not for use in Russia, and to actually go further and indemnify the OEM if the OEM were somehow found to have breached the sanctions by the operator's use of the aircraft in Russia. Obviously, this creates all sorts of legal concerns, particularly indemnities, and particularly because they were asking them to sign, not even the name of the operator as a business, but by the individual director of the company. And that's a huge ask of anybody, and particularly in such wide-ranging concerns. The other side has been aircraft that were deregistered because the registries decided that the aircraft were linked to Russians. And in all of these cases, I'm talking about non-sanctioned owners of aircraft. These are people who are not designated persons. We've had cases of aircraft grounded in Europe. And again, in that particular case, the aircraft actually landed the day the NOTAM came out. So it was en route into Europe when the NOTAM was issued, it landed and it was impounded. And obviously the owner of that aircraft wasn't able to do anything to mitigate its issue because it wasn't even aware of the NOTAM when it was en route. So it's been a battle because, I need to be very clear here. Obviously, sanctioned individuals and the Putin's regime are not something that any of us would want to support. But when we are talking about non-sanctioned individuals and people who can't even maintain, can't get parts to their aircraft, can't insure their aircraft, can't fly them, can't use them. I mean, I have a particular case of an owner of an aircraft who has resided in Europe for the last 30 odd years. He and my advice to him has been, no, you can't fly your own aircraft into house in Europe, but you can sit down the back of a British Airways flight because you don't own or control the British Airways flight. I mean, it's a little crazy in terms of trying to explain to these different people that, that they're not out to get you in terms of these sanctions. It's not you that the sanctions are intended to attack. It is obviously supporters of Putin's regime, but yes, you are being collaterally affected by it. So it's been a struggle, but what we have done, I chair the BBGA, which is the British Aviation Association, the British Business and General Aviation Association, and we have been working with the UK government for the past few weeks, just in terms of interpreting their approach and their policy, and to try and get some clarity, particularly for the aircraft that have been grounded, the ones that can't be maintained. And again, for non-sanctioned individuals, mainly because we're seeing a massive problem brewing. If an aircraft is stateless, if it has been deregistered, for example, and the deregistration will automatically remove, or typically would remove the certificate of airworthiness. So without a certificate of airworthiness, the aircraft is not technically airworthy from a regulatory perspective. And if the registry has taken all of that away, then the next step would be for the CAMO, the maintenance organization with oversight of the airworthiness of the aircraft. The next step would be for the CAMO to say, well, we can't act as CAMO because it's not an airworthy aircraft and we can't do anything about it, our hands are tied. And then the next step is the insurers, who will then say, well, hang on a second, how can we possibly continue to insure a stateless, non-maintained, non-airworthy aircraft? And the submission we've made to government is, you're creating an absolute mess here, and you need to give us clarity on this. These aircraft, if they are being deregistered, if the registration is being suspended, and because the regulators have reason to believe that there is some link to the regime, you need to be very sure of yourself in doing things like that, because there's a massive impact on residual value. It's a huge cost in terms of the aircraft. And, you know, it's not like these sanctions are, as Bajut said earlier, that it's a whole new world of sanctions with these Russian sanctions. They're going way further than any previous sanctions that certainly I've seen. The impact is huge. And I think that the amount of confusion out there, I mean, I often wonder with a lot of these people in the industry is, you know, did you even read the sanctions before you took the action you took? Because you're not allowed to do this. You know, these people are not sanctioned. They're not caught by it. So what on earth are you doing, removing the registration of an aircraft of a non-sanctioned individual? You've now created a stateless, non-airworthy, non-insured aircraft. And you know, what are these people supposed to do? So to be fair to government, they have been responding. We are getting a lot more clarity on it, and we're expecting to be able to get a lot more clarity on it. But, you know, for as long as these NOTAMs are in place and as long as these sanctions are in place, then yes, it is a very, very big issue for aviation. But I suppose my point on it to government has been, and my point would be to anybody, is it's not like freezing assets. Aviation is a whole new world in terms of freezing assets. You can't just freeze the bank account. You can't just lock the door of the property in Mayfair. You know, you have to look after these aircraft. The engines have to be turned. They have to be put on storage protection programs. If they're not, you are creating unwittingly a massive safety issue. And why would you do that? As I say, I understand I understand all of that in terms of sanctioned individuals. But when you're talking about non-sanctioned individuals who are just caught by the wording of the sanctions unintentionally, and the government have said that these collateral people are not intended to be caught by the sanctions, and our submission is, well, they're not intended to be caught, but they are being caught by it, then you need to provide the clarity on that. So that's what we're hoping to see within the next near while. But yeah, it's interesting times. It's very challenging. I think one of the problems with the legislation, these Russian sanctions, is this whole new world of the catch-all provision in the regulation that basically says, and by the way, if we haven't thought about it, and you think up something clever in terms of a loophole to get around this legislation, then we're going to catch you too. I mean, that's not legal clarity, is it? I mean, how can a lawyer give advice with that kind of a provision in a regulation? And I think that probably is what has created the confusion in the market, because there are so many people who are so afraid to give advice because they're afraid of being caught, and by being caught unwittingly by sanctions legislation that was never intended to catch any of them. So as I say, it's a whole new world. It's very, very challenging, and particularly in aviation, because these assets absolutely have to be looked after, if only for safety reasons.
Oh, thank you, Effie.
Thank you, Aoife and Safak. Just before you carry on, and just before we get to Samuel, who's been waiting patiently with bated breath, and actually, as Safak you said, has experience because of Venezuela of a sanctioned regime. We had a question come in via WhatsApp, which I put into the chat, and Bejel has answered, but just wanted to sort of open it up to see if there's any other comment, which was and potentially more relevant for private aviation. What happens if an aircraft is part owned by a Russian entity or individual, or part of the supply chain happens to be Russian? What are the implications then? Bejel says this is a difficult question. Understanding if the aircraft is controlled, or if the company that owns it is controlled or owned at least 50% by the Russian entity that is sanctioned, then it may be caught. I think, Aoife, you may have a perspective on this as well.
Yeah, no, that's right. It's the Russian owner, the Russian shareholder can't use the aircraft because of the NOTAM, but the other shareholders can. The question of whether it's owned or controlled by a Russian entity depends on the percentage. It depends on their voting power, and it depends on their shareholding. So you would look at it from an ownership and control perspective. Same thing as under the Companies Act. But what we would also look at is things like, we have in business and private aviation, we have fractional ownership of aircraft. So you can have a 1/8, a 1/16. We have concepts of shared ownership where you'll have, two individuals sharing ownership of a jet. What the policy has told us is that in the case of, for example, fractional owners, if one of them happens to be Russian, then that aircraft is not necessarily affected. It is more to do with majority. So it would be as you'd expect it, if they control it, if they have genuine. And funny, I'm sorry I was late, Keith, but the call I had just been on, we're talking about, well, what if it's legally owned by a company that's not Russian, and the shareholding is held by a company that's not Russian, and the directors are, so typical corporate services provision, isn't it then not a Russian aircraft? And I said, well, what are you saying? So, the money to pay the bills come from a Russian individual, but you're telling me that this Russian individual doesn't have any ownership of this jet. That it just can't be true. So you have to start looking at things like nominee shareholder agreements or trust agreements, et cetera, et cetera. The regulations, the sanctions don't just talk about legal ownership. They talk about beneficial ownership as well. And the legal ownership obviously being whose name is on it, the beneficial ownership being who is legally entitled to the benefit of the asset. So we do have to look at both.
Can I just quickly touch on exactly that point that Aoife's made? So you don't look just at legal ownership, you look at beneficial ownership, and you also look at questions such as who the directors are accustomed to act, on whose instructions the directors are accustomed to act. So, the directors might well be the ones in charge, but if, for example, they're used to acting on the instructions of a particular Russian individual, then the courts are likely to say that, well, this is therefore under the control of the Russian individual. So it's not a test that is dependent just on the legal schematics, but it does depend on the reality of the situation.
And that's very clear, Kate. In some cases, EU and the UK legislations have a different approach to the control and the ownership issue. So that's a really a critical point, especially for the supply chain issues. And because, as Aoife mentioned, it's not only a blocking or rejecting any transaction, and the control and the ownership directly, indirectly, which is under in general the 50% rule. Sometimes applied by the different sanctions regimes from the UK and the EU, especially in these Russian programs. And it's very critical to not to ignore the wording of for use in Russia. So no one can control anything to be used or not in Russia. And we have encountered many questions from other industries, from the clients, asking that how can I check my customer to use in Russia? Is it my obligation, or what will be the compliance procedures for that? So that's a really unclear issue, and I think it's generally to block all Russian, the benefits in the aviation industry. But I agree with Efe that is not really reasonable in the aviation industry.
The other point as well on that is it's not just the transport sanctions that you need to look at from an aviation perspective, it's also the trade and finance sanctions. Because what we've seen is that so say, for example, a Russian individual is trying to sell an aircraft, non-sanctioned again. The sanctions, if the sanctions don't apply and the sale can go through because the sanctions don't apply, you may still be caught by the trade and finance sanctions. So if, for example, the money from the sale finds its way back into Russia, then you may well get caught by the sanctions on that. As one of my clients said to me, but the minute I hand over £10, how do I know if that £10 is going to end up in Russia or not? The point of it all being, you need to do enough due diligence to be able to defend yourself, and you need to be very sure, because otherwise it really is not worth it.
What's great is I can see as everybody's been speaking, Samuel has been nodding along with the comments since Venezuela has been experiencing sanctions for some time. So maybe this is the perfect point then to jump on Aoife's comments and bring you in, Samuel.
Thank you very much. And I believe that one of the main issues when you try to understand how both the two sides of the coin, because you have the good side, which is, in the case of, for example, us lawyers, how do we provide enough counsel to our clients to comply with sanctions regimes? But then the other side of the coin, which would be the bad guys, which are the evading actors, those people, entities that are experts on finding loopholes and back channeling the sanctions. And what we have done in the case when Venezuela was heavily sanctioned, specifically under the Trump administration, it had been previously sanctioned by the Obama administration, but the Trump administration stepped up significantly the sanctions against Venezuela. And what we did, the exercise, and I believe that's going to be the thing I'm going to share with you all, is that by looking to the previous cases, the previous, let's say, sanction rounds, you can determine how these entities or individuals operate to evade sanctions. What have they done in the case of, for example, the Iran sanctions, which is the case we looked into because Iran has been sanctioned for decades. And when you see and you study how they operate, that can give you a very clear sense of what the red flags are and what you need to do to comply with the sanctions. In the case of Venezuela, for you to know, regarding aviation in Venezuela, just the United States, through the OFAC, has sanctioned the Venezuelan state-owned main airline, which is Conviasa. UK has also sanctioned Venezuela, but just individuals, as well as the European Union, normally members of Maduro's cabinet. But regarding aviation, it has just been the United States that has sanctioned not just this airline, Conviasa, but also aircrafts. And when we started to study how did, for example, Iran operated, how the sanctions in Iran got displayed, we found very valuable things. It's like, for example, to use a soccer analogy, like when you're going to play against an opponent, you see how they have played in the previous matches, and then you determine, okay, this is how they're operating. Hence, I need to reinforce these aspects of compliance. And the important question and the most important issue is that, first of all, you always have to prepare and do the most due diligence, as Aoife said, you can, to tighten up your know your customer policies, your compliance protocols internally, not just for clients that you already have, but also to potential new clients, especially if you're located in jurisdictions that are very prompt to, for example, aid sanctioned countries, which is of course the case of Venezuela. Venezuela is a country that is very politically tied and close to Russia and to Iran and to regimes like Syria. And if you are in those jurisdictions, and not even just those, but even in neighboring countries, for example, in the case if you operate in Belarus, you need to be very aware of your existing clients, the clients that you have, and also possible new clients, because what we found that the most common practices were in the case of Iran, and there have been reports of this happening in Venezuela, but not necessarily, not regarding to aviation, but regarding the oil and gas industry, which has been the most heavily sanctioned. And for example, the classic and most frequently used methods have been, of course, on the shell companies, companies that are based in tax havens or in countries that are very close to the sanctioned countries. For example, there have been many cases of, regarding the Iran sanctions, of companies based in the United Arab Emirates or in Qatar or in Southeast Asia, that they are based there, and given the proximity that also eases up supply chain matters, they tend to facilitate operations back channeling the sanctions. So the red flags that we have found that you need to be aware, not just if you're lawyers and you're counseling a client, but also if you're a company and you're making a transaction, if you're a company that's dedicated to selling spare parts, for example, which is an essential key, because the first thing that sanctions do is that they sort of put in a crossroad sanctioned airlines. For example, in the case of Iran, Mahan Air, that has been sanctioned, the first thing, and one of the most important things that gets affected is the security of its operations, because Mahan Air still is operating as of this moment flights. They're carrying indeed passengers, human lives, but their security issue is tampered with, because they cannot obtain spare parts, they cannot receive maintenance. And in some cases, regarding that case of Mahan Air, even non-Iranian and non-US persons have been sanctioned by merely providing training and assistance to Mahan Air pilots. This happened in 2013 with Ukrainian Mediterranean Airlines. They were sanctioned because they leased some aircrafts to Mahan Air, and they also helped to train and certify Mahan Air pilots. And they were sanctioned by both of these actions. They were sanctioned not just by leasing to a sanctioned entity as Mahan Air, but also by helping to train and certify Mahan Air pilots and engineers regarding those leased airplanes. So you'll have to be very aware of those third parties coming into play. If, for example, one of the most common ways of evasion is that, for example, you will find a third party, an entity that, let's say, is dedicated in the industry of food. And all of a sudden, you will find that that company all of a sudden is consulting you or asking your counsel regarding a transaction for acquiring spare parts for an Airbus. And that's a red flag that you have to be very aware of. Why all of a sudden you're making this operation, this transaction that has nothing to do with your industry and what your bylaws state. If you're a food company, then why are you dealing with spare parts? And that should be a red flag for you if you're addressing or counseling that client that comes with you to you regarding that transaction, or if you're the counterpart of obtaining that. You need to be very careful, and that's where you need to tighten up your compliance and your know your customer policies. For example, you need to carry on due diligence or even sworn statements. That is a very common used tool in Latin America and in Venezuela, a sworn statement in which or an affidavit in which the client states to you, even though of course we're not policemen, we cannot go after them, but the client disclaims to you that no, these operations is in no way intended to evade any sanction force, whether of the United States or European Union or any possible sanction out there. So always be aware of those transactions or potential transactions that go away from what the company normally and usually does. And also one of the other red flags you have to be aware for, and when you look at the side of how do I comply with is that always try to have transactions that regard whether maintenance agreement or the purchase of spare parts. You have to be very aware and try to push the counterpart to use payments through the US bank system, to use US dollars or British pounds or euros, because one of the most common means of evasion is that those people that try to evade the sanctions, they don't want to go through the US bank system. They don't want to go through the UK bank system, nor the European bank system. So you have to be aware when you receive quotations or payment proposals in rubles or in yuans or in local currencies of mostly other countries, third countries, that should be a red flag for you. And then comes in play your compliance principles of pushing the client or the counterpart to always go through the US banking systems, which of course does not exempt you from having to fulfill your compliance and due diligence procedures, but I believe professionally that it is a way for you to go even further to the largest extent that you can. Also, you have to be very aware, the other red flag is that if you are in the industry of, let's say, purchasing spare parts, we notice that you have to be very aware. If you're in the industry, you know the average price of, for example, engines or brake systems of the aircraft, and you know the market value, the average market value of those spare parts. A red flag would be when you receive a quotation that is 3 or 4 times the value. Well, why am I paying 3 or 4 times for this specific spare part when, for example, it costs $5,000? Why are you budgeting this spare part in $30,000? That's usually a red flag, because normally that means that it is going to end up in the possession of someone that is meant not to have it, and that has a blockade around him, and that is why he's willing to pay such a high price for that spare part. And this can happen not just with spare parts, but also with maintenance or handling services. So you should be aware. If you're in the industry, you're going to be already aware of the prices. But if you're new, be very aware and get yourself familiar with how's the market value of this particular services and why am I receiving these extremely high quotation. Also, you have to check very specifically regarding the favorite, let's say, chess piece of the bad guys, which is the shell companies. Always check the corporate record of the entities involved. Most shell companies, you will find that they have a very, very low corporate and commercial record. You will find that they have been incorporated in very recent years and often in jurisdictions that are considered tax havens. And for example, part of your compliance program and know your customer policies have to be, okay, I'm going to need your bylaws, I'm going to need commercial references, I'm going to need sufficient evidence to the extent that I can require that of the client for you to prove me that indeed you have conducted businesses, that you are not a shell company, and that's a way for you to protect yourself of dealing. And also something very important is that regarding sanctions, and when clients come to you and they have a question regarding a specific transaction, always, and I think that's the best practice. For example, in my case, I'm a Venezuelan practice lawyer. I am not authorized to practice law in the United States. Always seek for local counsel of the country that has the authority that is enforcing the sanctions. Because, for example, it happened a lot in Iran, in the case of aviation, that you would find, the US would find that companies were trusting in local Iranian counsel, and I do not mean this in a disrespectful way, but people that were sanctioned during the process, when they were charged, they would often say, but we were counseled that this particular transaction was not in the scope of the sanctions. And then when they turn to the other side, to a US known practitioner lawyer, they would say, no, of course it's in. And that's why actually the United States issued in 2019 a civil aviation alert regarding Iran. And one of the main things they alerted was the misleading counsel and misleading interpretations that people in Iran were giving to potential clients. And those guys would go as far as, for example, presenting fake OFAC licenses or alleging that they had OFAC authorization when they did not. So I will always recommend to you, to all those hearing, that for compliance purposes, get local counsel of the jurisdiction that is enforcing the sanctions. If it's UK, get local UK counsel. If it's the United States, get US counsel. Again, an invoice not billed is way cheaper than an invoice billed, but that has a summon notice from the FBI. So those are efforts that you cannot disregard. And finally,
okay.
Yes.
Wise words, Samuel. We've had a question come in, and it's something that Aoife touched on as well, which, you know, a lot of talk about sort of shell companies. And in terms of past experiences of sanction regime, how can we identify, geographically speaking, potential shell companies? I mean, that's a very big and wide question, but you know, I'll put it to you, Samuel, quickly, and then to the rest of the panel. I'm aware we've gone over time, but if the panel will stay with us and you're happy to stay with us, I've had one more question come in after this. And then I know, Safak, you wanted to mention something about force majeure, but let's talk about shell companies first of all.
Well, in this case, as I mentioned, it is very important for you to be aware in the case, for example, if you're looking into compliance of Iran sanctions or Venezuela, you need to be aware that, first of all, of political companies, political countries that are aligned with it. For example, as I said, in the case of Venezuela, Venezuela has openly declared its support to Russia, as well as Nicaragua and, for example, countries like Cuba. So you have to be very aware of how the jurisdictions in which those companies are based, how are they aligned politically. You also have to be aware if they are based in tax havens. And also in the case of Iran, we've found out that many bordering countries, specifically those in the Arabic Peninsula, were very prompt to assisting Iran in sanction evading. So you also have to be aware of neighboring countries that aren't aligned with the country that is imposing the sanctions. In Iran, it has happened, as I mentioned, with the United Arab Emirates and also with Indonesia, for example. There was a big case in 2019 of Indonesian companies that were channeling spare parts to Mahan Air. And what they found out was that pattern, the pattern of regional countries that were not necessarily enemies, let's say geopolitically, of the United States, but that they were to a certain degree aligned with Iran, or at least neutral in the geopolitically speaking. So political aspect you have to take into consideration.
Any comments from anybody else around the panel?
All right, I've just on the shell companies, one of the things to note is obviously in aerospace, we tend to put each aircraft into individual structures. And you know, we're not doing that to make life difficult on KYC and due diligence. We're doing it to ring fence the liability and protect others. Or it can be for reasons of bankruptcy remoteness, you know, you're protecting the lessor, etc. I think it's probably fair to say though that look, if it looks like a fish and it smells like a fish, then it's a fish. You know, you need to really ask the questions. And I don't necessarily agree with what seems to be a general consensus is that, you know, nobody really knows who owns these aircraft, and particularly this now in private and business aviation, and it's very difficult to find out who's actually behind it. And I mean, frankly, I think that's rubbish. Of course, we know who owns these aircraft, and you know, any lawyer who helped the individual buying the aircraft must know. You have to dig, and you must know where the money is coming from. Otherwise, you're in breach of the anti-money laundering regulations, and they're just as serious. You know, it's personal criminal liability. So we take it all very seriously. So I think if you find yourself presented with a shell company in terms of a transaction that you're dealing with, and when you start doing your KYC and your due diligence, and that particular company just doesn't stack up. I mean, we've had instances, for example, where, with all due respect to all of us as lawyers, but you know, it was a lawyer who was the front of the company. The lawyer was the shareholder and the lawyer was the director, buying an $80 million jet. And, you know, even with the best will in the world, I don't think we lawyers earn that many fees to buy ourselves an $80 million jet. So you just keep asking. And if they won't answer your questions, then you can't trade with them. You shouldn't. You can if you want, but you shouldn't do deals with them because they are clearly hiding something. So I think that that's one thing to learn from this. I think probably, sadly, KYC is going to get a whole lot worse following this particular regime. You know, it was painful before. It's gotten about 10 times more painful. We just have to do it. Lawyers have to ask the questions, and if you don't get the answers, you shouldn't act on it. Sorry, Samuel, over to you.
Yes, also another thing that, for example, it's a great tip-off regarding shell companies is that, for example, they will use bank accounts in jurisdictions or financial institutions that are not in the same jurisdiction in which they're based. So let's say a company that's based in, let's say, X country, but all its bank accounts are located in the Z country. That's also a great tip-off. And a practice that, for example, banks use and could be used by suppliers is to in-person check the existence of the companies, you know, physically located, their commercial and financial address inspections. And I believe that regarding the first one, it's a great tip-off for shell companies that are based, let's say, in the United States, but have bank accounts in other countries and are not financially related and settled in the United States. I believe that's a tip-off regarding shell company.
I just want to add some words. When the sanctions is an issue in aviation, and when you combine it with the financing of that, I have encountered some issues that one of the clients was provided a credit line by the bank, and the part of the repayment schedule to the bank is based on the receipt of the payments from the third parties, but the third parties are sanctioned. So how you will secure the repayment and how you will secure this transaction? And so there are too many complicated issues in the aviation: the funding, ownership, controlling, and the supply chain. But there is also one reality that there's a saying that buy when there is a blood in the streets. You don't think if there will be any advantages or any chances to take over, or new acquisitions, or the commitments for the acquisitions now, maybe after this all sanctions, you know, dust is settled down, there will be a new M&A market in the aviation industry. What do you think about that?
Can I just come in on a couple of the points very briefly? Samuel made a very interesting observation earlier about the fact that, you know, you might have a food company that is seeking to buy aircraft parts, and that touches on quite an important point, that we're not just talking about shell companies that are being used by sanctioned people to procure services, but sometimes they may be using legitimate businesses as a front for other activities. And so it's important to bear in mind that the problem is not just a shell company point, but it's actually much wider. It's whether a legitimate business is being used for other purposes. And I think from what Aoife and Samuel were saying, and this accords with my experience on English law, the test is always a test of what is actually the position on the facts of the case. So you have to look at the whole situation to see who is actually controlling the entity and calling the shots. Or the transaction.
That's fair comment, Bajula. I mean, we've had cases, for example, where during the acquisition process, we had doubts about the buyer. The buyer stacked up in terms of it did appear to have the credit, it did appear to have the type of cash, but just something didn't seem right about it. So when they went to do the viewing of the aircraft, we asked the operator to send us copies of the passports. For, you know, to get airside, they had to provide copy passports. And sure enough, you know, despot dictator turned up on one of the passports. So we had to reverse very quickly back out of that transaction and to report it. The other side of it, and following on from Samuel's point and Bajul's point, is actually in private business aviation, it's very rarely that it's an aviation business that comes to you looking to buy an aircraft and looking to buy parts. That these are aircraft that are used by corporates, big businesses all around the world. So I suppose what I would say is don't just distrust them just because they happen to be a food or a retail business, in terms of coming to transact with you. But I think probably the message very clearly from this webinar is you have to ask the questions, and you have to keep asking the questions until you're absolutely satisfied. Because it is, as we say, it's personal and it's criminal. This is not something you can pay your way out of. It's criminal.
Sort of conscious of the time, and we've packed a huge amount into the last hour and a quarter. So very, very grateful to our panel. It sounds to me a little bit like turbulence is here to stay for the aviation industry. I will be circulating the contact details of all our panelists if there's anything you wish to pick up with them on the back of today, or something that you've heard. Sort of, most of all, thank you very, very much for joining us today. And Shafak, Bajul, Aoife, and Samuel, thank you so much for your insights. I think the way things are going across the world, we may be seeing you on another panel in a few months' time discussing the next stage of aviation, and perhaps the next lot of turbulence that's coming our way. So I suppose fasten your seatbelts, and we'll see you soon. Thank you very much, everybody.